All right, everybody. Welcome back to the final panel of the conference. Again. For those of you who weren't here yesterday, my name is Sarah Rippey, and I have been the symposium editor for this event. For our last panel of the day, I would like to give a special thanks to Brian Tremont for stepping in at the last minute to moderate our discussion of internet platforms and competition policy. Brian is the managing partner at Wilkinson Barker Knauer in Washington, D.C., and is an adjunct professor at the Catholic University of Americans Communications Law Institute. He is also an executive fellow at Silicon Flatirons and is known here at Colorado Law for the truly invaluable mentorship he provides to CU Law students and alum working in D.C. Brian?
Thank you, Sarah. I appreciate it. It's good to be here with everyone. As Sarah alluded to, and as I was discussing with her last night, my total experience in antitrust was a single class in law school. And when I say a single class, it was during ad drop week, and it met at 8 in the morning, and I literally went once and then dropped it. So my skills here may be somewhat limited, but I'm going to do my best to moderate our all-star panel this morning. And we're going to start, this format will be the same, so 15 minutes for Doug and for Carl, and then Babette and Jeff will each have 5 minutes to respond, and we'll start with Doug.
Okay. I'm going to stand up. I don't know why. Seems appropriate. Carl wants to.
Yeah.
So I was asked to talk about the Supreme Court's decision in the American Express case last summer. I agreed to do that. It's an interesting case. And then I realized sometime thereafter that I was not actually going to be given 2 hours to do it. So I'm going to pick a subtopic. And that question that I'm going to address is this. What does that case tell us about the court and about the fate of competition policy with respect to platforms to the extent it reaches the court? So let me put this in context. We all know that antitrust statutes passed more than 100 years ago, very short, very vague. It's a common law like a law. It evolves over time with a dialogue between courts and the academy and lawyers and so forth, and the doctrine changes. That's been one of its great strengths. It's adapted to the modern world. Beginning in the 1950s, a bunch of scholars, which are now called Chicago School, were dismayed by the then current state of the antitrust law. And they did some really serious economic and conceptual analysis. It was very fact-based. They wanted to get behind cliches and intuition and labels and really look at the substance of what's going on. And they brought their new learning to the courts directly and indirectly. And they won the day, starting with the Supreme Court's 1977 decision in GTE Sylvania, and Chicago School became an important sort of frame for antitrust thereafter. The fundamental contribution of the Chicago School was the normative idea that antitrust doctrine should be fashioned with rigorous focus on economic welfare. And I think most of us agree that's a good and enduring contribution. There are some current critics today, but I'm going to leave them aside, and I'm going to start with the premise that the Chicago School correctly taught us all that antitrust should be rigorously focused on economic analysis. The Chicago School folks also in that generation embraced some factual propositions, 3 of which are particularly important in this case. 1, vertical restraints cannot be anti-competitive. 2, vertical restraint transactions can be presumed to generate efficiencies by eliminating channel conflict. That is to say, you have a distributor and you have a manufacturer, and they each have a self-interest, and if they can't coordinate, you don't have an optimal distribution, and transactions between them can create efficiencies. And factual proposition 3 is that false positives are a bigger problem than false negatives. 40 years of learning since then. And the new learning and experience and data over the past, actually 50 years, have demonstrated that these unqualified propositions have not stood the test of time. At the very least, they need to be substantially qualified. Now, a healthy antitrust common law process would take the new learning into account, as it did in the 1970s, and while adhering to the enduring normative economic welfare focus of antitrust law. The 5-4 Supreme Court majority failed to do that in the Amex case, and it failed in ways that I think are very worrisome. All right. The case was about the credit card business. Credit card systems collect money from both consumers or cardholders who pay annual fees and interest on revolving payments, and from merchants who pay a merchant fee. They're in effect selling their services to both sets of trading partners. It's therefore regarded as a platform or a so-called two-sided market, because it has these two sides, the cardholder side, the merchant side. And they're interdependent. Merchants aren't going to take the card if nobody carries it, and nobody's going to carry the card if merchants don't take it. Okay. American Express is the only case in the history of the United States antitrust law explicitly to focus on the implications of a multi-sided market. There have been other multi-sided market cases before, but they never found it necessary, correctly I believe, Microsoft, Lorraine Journal, and others, to focus on the multi-sided aspects of the case. This court, I think, rightly did focus on those aspects. The problem that gave rise to the case is this. Compared to its closest competitors, Visa and MasterCard, Amex has higher merchant fees. It uses those to fund higher benefits and rewards for its cardholders, and it attracts a wealthier and perhaps more profligate cardholder overall than does MasterCard and Visa. That's just business model. But the higher merchant fees have a problem, because if you're a merchant and someone comes to you and you have a choice between paying 5% of the price to American Express or 2% to Visa, you'd rather pay 2% to Visa. So you have an incentive to say to the customer, why don't you use Visa instead? And Amex, to prevent that, has adopted so-called no steering rules, which say to the merchant, if you take Amex, you can't steer anybody to other payment vehicles. You can't even pass on to Visa and MasterCard customers the lower merchant fees that I'm having to pay as, in effect, a wholesale price for card services. You have to charge them all the same price. Okay. The lawfulness of those steering rules was the issue of the case. The district court found some important facts. The district court found that the no steering rules reduced the incentive for Amex and its competitors to compete on price, for the obvious reason that the lower prices, lower merchant fees, couldn't be passed on to cardholders and created an incentive for them to use the card more, so why cut your price? That the effect of the no steering rules was to exclude rivals like Discover that wanted to compete on the basis of price with new business models. That they resulted in higher merchant fees across the board for all credit card companies, and that those increased merchant fees were not offset by increased cardholder benefits. In other words, there was a net increase in the cost to the consumers of credit card services. The majority ruled for the defendant. It may be that American Express's policy was lawful. I think that's conceivable, unlikely but conceivable. But what bothers me about this decision is not that bottom line so much as the way the court analyzed the issue. It made three fundamental errors, which I think reflect on its just not having absorbed the new economic learning over the past 50 years. First, it held as a matter of law that in a vertical case, and these were vertical, this was a contract between the seller of credit card services, American Express, and one of its customers, the merchants. In a vertical case, a market must be defined in order to prove injury to competition. Now, this is really weird. Market definition is a kind of indirect, a kind of circumstantial evidence to which antitrusters turn to help them figure out if there's been harm to competition when they cannot prove that by direct evidence. Court held not simply that the circumstantial evidence might be helpful, but that it is an element of the offense. They've added a new element now to the plaintiff's case. How did they do that? First of all, they had to distinguish a whole mess of Supreme Court cases that said you don't need to define a market in an antitrust case if you can prove competitive effects directly. And the court said, oh, those are horizontal cases. This is a vertical case. This is like Robert Bork saying you can't have an antitrust problem with a vertical case because, the court said, vertical transactions can be pro-competitive. By the way, So can horizontal transactions, as we all know from all sorts of joint ventures and other good things that happen because of vertical collaborations. Okay. The only support the court cited, by the way, for its holding was Frank Easterbrook's 1984 article. It was a classic back in 1984. They cited it in support of its that the market has to be proved. They quoted a passage which didn't even say that. In effect, the court converted a tool intended to aid fact-finding into an additional element the plaintiff must prove. There's no legal or economic support for that rule, which will increase the likelihood of false negatives and decrease the likelihood of correct results when competitive effects can be proven directly. Second, the court held that in so-called transaction platforms, the one market must include both sides, cardholders and merchants. It seemed to think that it was because it defined the transaction market as one that facilitates a simultaneous transaction between both sides. In that case, you go to the store, and the credit card enables you simultaneously to have a transaction with the merchant. He gets paid, you get the merchandise. That's a transaction market. The court seemed to think that simultaneity was reason enough to put them both in the same market. By contrast to the Chicago school tradition of deep factual analysis of the actual economic implications of what it was doing, the court reasoned entirely formalistically. There was no functional analysis of what does this mean for an antitrust case. But what functional implications? Let's think about that. Number one, it's totally unnecessary. Affects the relationship between the two sides. You don't need to put them in the same market. You can do it as a simple empirical matter. If, for example, you want to find out, does Amex have market power sufficient to enable it to raise price against merchants? You can ask that question empirically. And if raising the price costs a few merchants to give up the Amex card, but not enough to make it unprofitable, you can go further and you can say, but wait a minute, if a few merchants give up the card, maybe some cardholders will give it up because their favorite merchants no longer take the card. And then if those cardholders give it up, maybe other merchants will say, oh, now I'm going to drop this thing. It's not the fees, it's the fact there are fewer cardholders. And you might determine by looking at all of that the price increase is not profitable. You didn't have to put them in the same market to do that. Simply look at it as a matter of factual context. So not only was the holding unnecessary for any serious factual inquiry, including the feedback effects between the two parts, but it creates a lot of complications. It greatly complicates proof of the relevant market. Relevant markets are defined in order to identify the competitive constraints on economic actors. So you define them. There's a well-developed economic and legal methodology. You define them, in effect, by creating concentric circles. You start, first of all, with American Express. You say, is it a market by itself? And if not, you say, well, who are the closest substitutes? Visa, MasterCard. Let's look at them. Are those three? Do they constitute a market? And you keep expanding the market, the hypothetical market, until you find one that meets the tests of an economic market, an antitrust market. Now, if you have to include both sides, and if the competitive constraints don't align the same way on both sides, then you have an incredibly complicated problem. Okay, I'm going to add Visa on the cardholder side. Which one do I have to add on the merchant side to come up with a market? So you've created a complex set of pairings and combinations in order to assess market. Again, not necessary to do that. It also makes market definition less useful. One of the reasons we define a market is that then we can look at market shares and draw some inferences from them. Intel had 80% share for forever, so people started saying it had monopoly power. What if it would have been a two-sided market? 80% on the merchant side, 20% on the cardholder side. What inference are you going to draw? Now, some people may say, wait a minute, it's a transaction market. Simultaneous transaction on both sides. Aren't we talking about identical markets? Now, that's the only purpose I can imagine for a special rule for transaction markets. After all, you have a special rule for transaction markets. It's a heyday for lawyers, right? They can spend millions of dollars restructuring deals to try to get the transaction classified as a transaction market or not, and then they can litigate whether it should be classified as one. Leave aside that legal process problem. the premise of the transaction market and the analysis must be, well, the transaction markets identify that subset of markets where the competitive constraints are the same on both sides, so why not throw them all in the same market? But in fact, the definition doesn't work. Think of Uber. Uber is plainly a transaction market, right? You've got a simultaneous transaction between the drivers and the riders. Now, what are the competitive alternatives or the constraints facing Uber on the rider's side? Well, it's Lyft, private cars, taxis, friends' cars, bikes, scooters, walking. What do the alternatives drivers have on the driver's side? Lyft and Grubhub, I think. That's about it. So the transaction market, the transaction market definition doesn't even serve that functional purpose. Okay. Finally, it complicates requiring one market complicates the assessment of competitive effects. Plaintiffs in antitrust cases have to prove harm to competition in the market as a whole. Take a case like Microsoft, Lorraine Journal. Harm was proven on one side. Is that harm to competition in the market as a whole? What does it mean? Here's what it means. It means that the plaintiff has the burden of proving that there are no offsetting efficiencies or benefits on the other side. Now, that means that we put the burden of proof on a party who has to prove a negative and who has to prove it about a proposition, benefits from the transaction, as to which the defendant almost always has more knowledge and better access to information. Putting a burden of proof on someone to prove a negative and when he's in inferior access to information is a recipe for factual errors. Okay. Here too, formalism and ideology drove a legal rule that serves no apparent purpose, it seems to me, other than to increase the likelihood of false negatives. And correspondingly, in fairness to the court, reduce the likelihood of false positives. Okay. But the most important problem with what the court did is the way it approached competitive effects. It was plainly mesmerized by the fact that this was a vertical case. It focused largely on the intra-brand vertical efficiency, about which more in a minute, instead of focusing on the anti-competitive intra-brand effects that were the subject of the litigation. I could talk about this for several hours, but let me just make a couple of points.
Yeah, okay.
Jordy, how much time do I have, by the way?
You're pretty much at the end of your time. So like, let's do 2 more minutes. I was trying to do the subtle, here's the clock thing, but that didn't work. So yeah, about 2 more minutes.
Okay. So, okay, give me a couple minutes.
Sure, okay.
Okay, all right. The majority ignored the findings of the district court. Most important, higher prices across the board, no offsetting benefits, higher net prices. It held that the plaintiff has to prove either a price in excess of the competitive price or a restriction in output. Now, leave aside the fact that you don't need either of those in order to show injury to competition. The Microsoft case proves that. Leave that aside. And leave aside the fact it's almost impossible to prove the competitive price. What the court is really saying here is you have to have direct proof. You have to directly observe the injury to competition. You can't prove it by circumstantial evidence, like the fact that the price went up and no offsetting benefit. Think about that. We can convict people of murder on the basis of circumstantial evidence, but we can't prove harm to competition on the basis of circumstantial evidence. Oh, and by the way, think of what they did when they required the proof of circumstantial evidence when they said you had to prove a market. Okay. I'll be very quick, but I got 1 or 2 more points I got to make. The majority credited this, the justification, the intra-brand justification of Amex, which is basically, it's going to erode our goodwill if customers come in with our Amex card. They were attracted to the store because you had Amex there, and they're steered to another card. This summer, I happened to go buy a handbag for my wife. I don't know anything about that. I called my daughter. I said, what do I do? She said, go to Saks. So I went to Saks. I walked in the store. I noticed a little alcove to the left. I walked over, and I'm looking at some handbags, and a salesperson comes up who was not perhaps the sharpest knife in the drawer and said, oh, you have good taste, sir. These are our most expensive handbags. So I said, let's go somewhere else. And I bought a different handbag, and my wife took it back. But in any event, I was thinking about that afterwards. Can you imagine? Imagine a world in which Gucci says to Saks, you sell my handbags. People know that. That's one of the reasons they go to your store looking for handbags. So as a condition of selling my handbag, you have to promise not to sell anybody else's handbag at a lower price, even if the wholesale price is much lower. Anyhow. The court credited this free-rider justification, in spite of the fact that it ignored district court findings that the record did not support the efficiency. It did not inquire into whether the efficiency increased total sales or just shifted share to Amex, and without considering possible less restrictive alternatives, of which I can think of some. In effect, harkening back to Robert Bork, they presumed the efficiencies without any inquiry. Finally, last point, they overlooked an obvious inefficiency and externality from this rule, which basically says if you can't pass the higher cost of Amex on to Amex users, you have to pass it on to all users. By raising merchandise costs to everybody, in effect, you get the Visa and MasterCard people to pay for Amex. Not a bad deal for Amex. Okay, what does all this amount to? It's a terrible decision. It establishes a bad precedent, but the biggest problem, it seems to me, might be what it says about the 5 justices on this court. I believe they have conflated the enduring, valuable learning of the Chicago School about the normative focus of antitrust on economic welfare with factual propositions from 50 years ago that have not stood the test of time. And that they are willing to decide novel issues on the basis of abstract theories. It is a triumph of ideology over fact-based decision-making.
Tom?
Sorry about the time. That's great.
Now, I'm supposed to follow that by explaining what we can do positively with antitrust. I guess I will try to speak somewhat more slowly, but with equal passion. We're in an antitrust moment. I've done antitrust for a long time and have been working for probably 25 years at least. So yesterday and today, antitrust has come up, even when it really had no business coming up, because it was about some other topic. But people are looking like, we have problems with corporate power. We have all these problems. Isn't antitrust the solution? Isn't that what Teddy Roosevelt, told us 100 plus years ago? So I have a paper, Antitrust in the Time of Populism. It's on my website. If you want to hear more about this than the 45 minutes I've been allotted. Oh, it's not quite 45. Okay. Okay. Gideon, I heard you say antitrust is a crude tool. I will try to wield that tool as best I can. But let me start by actually harkening back to what Commissioner Chopra said yesterday at the beginning of the conference. He had, I think, 3 great points related to this. We're interested in competition issues, civil rights, and democracy, which is 3 parts. Okay, I'm going to focus on competition because that's my expertise. But I want to frame it first by saying, look, I think a lot of the desire to have antitrust do more is because of these broader concerns. Corporate power, problems with excessive corporate influence on politics, even corruption, the increase in profits as a share of GDP and the decline of the workers' share of GDP, inequality generally, the sense that the system's rigged. Okay, so all these things. But there's also a lot of other stuff, particularly regarding the tech platforms that we've heard about, more like privacy and the impact on democracy, as Commissioner Chopra said. So I want to kind of start with that generalized concern and then move it down into antitrust and what we can and can't do with antitrust. Okay, all right. So the title of this session, Internet Platforms and Competition Policy. So let's first, what do we mean by competition policy? I think it's a reasonable definition is a variety of policies intended to promote competition. And I would put that into 2 big buckets. And I really do distinguish these, an important part of my message: antitrust enforcement, and then various forms of regulation to promote competition, okay? And the regulation is typically or almost invariably going to be sector specific, and many of you are deeply familiar with telecom regulation, of course. Okay, but we go back of history, it's going to be railroads as well. We had airline regulation, okay? Now that left kind of a bad taste in a lot of people's mouths that the regulation does, at least price and entry and rate of return regulation doesn't work so well. But I don't think anybody here who's talking about regulation was really talking about price and entry and rate of return regulation. We're talking about other types of regulation, so we'll come back to that. So now I'm an antitrust guy, but I am also an industrial organizational economist, so I've thought a lot about regulation. With Phil Weiser together. Phil, of course, immediately gave me a copy of Digital Crossroads, and I had to read that. Well, actually, I don't remember that part. I will say it took me so long to read. There was a gap in antitrust enforcement for a month or two there, but I learned a lot. And as an antitrust person, I tend to think, well, regulation is what you resort to when antitrust and competition isn't working very well because you've got durable monopoly power, bottlenecks, and all that stuff. So we kind of don't want to go there unless we have to. So that's my starting point, okay? But I will say almost everything I've heard yesterday and earlier this morning, the concerns, the harms that you're concerned about, and so am I, they're really much more suited for regulation. If you're thinking antitrust is going to deal with those problems, you're very likely going to be disappointed. And not just because of the current makeup of the Supreme Court. It's a longer doctrinal issue with what antitrust can and cannot do, and federal judges can and cannot do with the cases brought before them. So, I'm actually believe, I won't go into this in great depth, but I think we're long overdue for regulation of these tech platforms. I think the loss of trust, we've heard that word earlier, is profound in many ways. Facebook has contributed to that, unfortunately. And it's not enough. These platforms have such power over our society in so many ways. It's not enough. We can't just say, oh, tell us how you do it, and we'll trust you to do it right. Too many implications, and again, Commissioner Chopra, civil rights and democracy, and probably more. So I think it's long overdue. And the question is how to do that and who's going to do that. I think we're going to keep having that debate. Okay, the Federal Trade Commission seems naturally placed, but that's a separate issue about how we do it. Sure seems like it needs some more statutory authority. But those things, all those things we're talking about, content moderation, a lot of the privacy issues, those are not fundamentally about competition, right? Those are what some firms are able to do because they have powerful positions and they have a lot of control. It's not a matter, well, those things are not a matter of eliminating competitors, colluding, or mergers. The traditional issues of antitrust, they're about how the power is being exerted or exploited, just like charging a high price, but it's getting a lot of your data, whatever. So that is not going to be an antitrust issue, at least in the United States. Okay, I'll talk a little bit about how the Europeans are different in a moment. Okay, so when we focus on competition, so now, okay, what can antitrust do? Okay, let me turn to that. And there are forces out there, there are voices out there that are really saying, antitrust has become so narrow and technocratic, it's ineffectual, we need to really radically change it and get rid of the consumer welfare standard has become a target here. I think that's completely misguided. I want to relabel it because people don't, partly because the critics of the standard have mischaracterized what it is. It's not just about consumers. Okay, it can protect workers as well. And it's not just about short run and price, it absolutely includes innovation. So it's been misunderstood, mischaracterized, including by the courts sometimes, but mostly more by the public. So I'm promoting the protecting competition standard, but it's really a rebranding, not a fundamental, thank you, I've trademarked, by the way, in case it wasn't clear from the comments. Okay, so under that, and then we got people calling, we should break up Google or Amazon or whatever. And I'm like, whoa, where did that come from on antitrust grounds? Okay, where is that supposed to come from? So now I want to say a little bit more what antitrust can't do and then what it can do. So a critical thing that I know most of you probably know, but some people don't seem to know or haven't integrated into their thinking. If a firm gains a dominant position by virtue of competing on the merits, as we say, which is better products, low but not predatory prices, okay, basically serving customers, it's not illegal. We kind of applaud it, although we don't necessarily love the monopoly that results. I'm going to quote, I have a quote here from Judge Learned Hand this is the Alcoa case from 1946 or so, I think. It's just a great quote. I couldn't say it better, but people need to remember this, okay? Merely by virtue of his superior skill, foresight, and industry. In such cases, a strong argument can be made that, although the result may expose the public to the evils of monopoly, the act, he's referring to the Sherman Act, does not mean to condemn the result of those very forces which it is its prime object to foster. Finis opus coronat. A little Latin there. See if you can figure out what that means. The successful competitor, having been urged to compete, must not be turned upon when he wins. Well written. I really don't think there's much support for departing from that view, in the United States at least. Okay. First of all, I think it would be incoherent in terms of competition policy. It would be unwise. I just don't think there's support there. So people who say we should break up these firms because they have all this power without reference to anything particularly they did, they are departing from this principle. And I think that is a dead end and a bad idea. Okay. Right. So, and I would think, look, my starting point, if you have a firm that's, let's say, I like the terms dominant firm and abusive dominance. Those are the European terms. I find them much more helpful than monopoly and monopolization. This monopoly makes it seem like, well, there's the only supplier, but that's not what we mean. Dominant firm, and then abusive dominance, what did they do to abuse the position, the dominant position? So I'll use that language, even though it's the European language. Look, there are no doubt firms that have obtained or maintained dominant positions through abusive conduct, but there shouldn't be a presumption of that just because they've achieved. So if you're going to talk about breaking something up or even conduct remedies, you really have to start, what did they do wrong? Tell me what they did wrong. And that's not my first question, all right? If you don't, whether it's Google or Amazon, you name any of these terms. But look, the start of the conversation is not, are they powerful? Of course they're powerful. The start of the conversation should be, all right, what did you think they did wrong? Let's talk about it. Okay, so that's what you should ask anybody when they start going this direction. Okay, and that requires investigation, and I can't do all that right now. And then when you start to go that way, you think, well, wait a moment, why did we lump together Amazon and Facebook and Google and Apple? Completely different businesses, completely different companies, completely different histories. Yeah, they're all powerful, but we should have to talk about them individually if we're going to talk about this coherently. It can't be some sort of lumping together. And by the way, if we're talking about them, wait, maybe we should talk about power of AT&T or Verizon or Oracle or Visa or, I could go on, okay? And again, when I say a firm has a strong dominant position, it's not disparaging them. In many ways, you're congratulating them for achieving that, unless they did something wrong. Okay, so, and then we got to remember antitrust rules. They are meant to and must apply across the whole economy, across all industries. You want regulations, sector specific, go for it. But antitrust, it better be principles that we're going to apply generally. Okay, it's a great discipline of antitrust, and I think it's helped antitrust prevent being captured because it's not industry specific. So whenever we say, what did they do wrong? That's when we get into analysis of, all right, what general principles will we apply? And we do have a lot to learn from a century or more of jurisprudence here. Now, I agree with Doug, there's some real problems with how ideology and lack of looking at the facts and using poor economics or simplified economics that Chicago lawyers thought up has led us astray. But we need to look at the conduct. Okay. All right. So, if we then talk about abusive dominance and look at the conduct, the Microsoft case, the US v. Microsoft case from 20 years ago now is, I think, very helpful, okay? Doug knows a lot about that, both in terms of seeing what type of conduct can cross the line in the US, and then how the Europeans did it differently, okay? So the case was about Microsoft defending their Windows monopoly, desktop operating systems, in the face of various threats, particularly was caused by browsers and Java, and there's a whole bunch of stuff there. Many of you probably know that. Okay. So first, it's a maintenance monopoly case. They abused their monopoly by doing things to keep out nation competitors who weren't really frontal competitors yet, but who were nipping around the edges and could have grown. That's a framework I think is extremely useful. Most of the cases, if we're going to be talking about abuse of dominance by today's tech platform, it's going to be that we want to look at. Are there threats that they're seeing coming abroad, and are they doing something to exclude those threats that is not a legitimate form of competition? And then we'll talk about acquisitions as well. That'd be the other category. So there's abuse of dominance, and then there's acquisitions that might be anti-competitive. So, you get into this. The Europeans, however, so they had another case against Microsoft, which involved Microsoft leveraging or extending its desktop operating system monopoly into operating systems over workgroup servers because the two interconnect, right? And they gave preference to the servers that had a Windows operating system, and that made it hard for other servers to run the workgroup because they had to connect with the desktops and protocols. The Europeans were willing to go much further in terms of interoperability, open interfaces as an antitrust violation. That has been a difficult area for plaintiffs in the United States, and the DOJ did not go there. Okay, they did have a tying part of the case revolving browsers, but in the end that was dropped and didn't do as well in the DC Circuit. So a key point here is you start to think about whether it's defending the monopoly, but particularly extending it into adjacent markets. We have a pretty cramped legal case law where, in the sense, another way to put it, we give firms a lot of running room under as legitimate business justifications for controlling those interfaces, whether we think it's intellectual property or very limited role of duty to deal under antitrust. However that comes about, those cases are in the realm of what antitrust can do to sort of an equal treatment, terms you're used to from telecom regulation. If you've got a bottleneck, equal treatment of people who are connecting to that. But those are all very hard antitrust cases. I'm not saying you can't do them, but if we were wanting to make progress here, we'd want to widen the aperture there. Okay, and that would presumably have to go through development of case law. And the way these things, it could be a private case or it could be a government case. That's where I think the action will need to be interfaces or equal treatment. But don't kid yourself, this is not an easy area for antitrust under precedent. And with the Supreme Court sitting the way they are, and all the more so with Justice Kavanaugh replacing Kennedy on this, it would look very hard unless they really change their thinking on the court there. It would look very hard to make progress here on these fronts. Okay, so that is, I have to say, not very optimistic. And by the way, not embracing everything Europeans are doing, but there is a big difference there. And it's not just a matter of personalities in terms of the Europeans doing more than the U.S. Their law is really different, both in terms of the European Commission's authority, a lighter judicial review, and a different case law. They have a notion of the special responsibilities of dominant firms that's much more imposing duties on dominant firms to almost promote competition. And we have a more narrow view of, no, you don't have much by way of duties, you just can't do things that are exclusionary, and that has to be defined. So that I don't think is going to change, and that's why we keep seeing a lot more action in Europe than we do here. And with even more aggressive movement with the German cartel office against Facebook lately, they don't have time to get into, but that's something even further afield would be almost unthinkable under U.S. antitrust law anyhow, and they have a different legal regime. The last topic, how am I doing on time? Oh, only 30 minutes left to go. So the last thing I want to just mention is acquisitions, okay? Because I said that the main areas for antitrust here would be abuse of dominance for a tech platform, and then what about acquisitions? And it's come up a couple times in different panels. I think Hal talked about it, others have. People talk about the examples, the most salient examples people talk about, I think, here and other places. Google buying YouTube, 10, 12 years ago, and Facebook buying Instagram and WhatsApp. We could talk about what about Microsoft buying LinkedIn, right? IBM's buying Red Hat now. Apple bought Beats Music. You could think of a lot more examples, and then you could go down from there to ones that you kind of shrug your shoulders, like hard to see much of a problem. Including, I have to say, Amazon, Whole Foods. I don't see why there could have been much there. Some people don't like it because it expands their empire. So the key issue is going to be which of these acquisitions substantially less than competition. Okay, at least I'm thinking more horizontal than vertical. So the key is, are they buying is the tech platform buying a small company that is a threat to them in the future? Okay, I think, again, the case law here under the potential competition doctrine is very cramped and needs to widen the aperture here too. I'm not quite sure how to get there. I would hope the agencies could move in that direction because the merger enforcement is predominantly up to the DOJ and the FTC here. So think of two different, first off, it's very hard to know, right? You take any of these examples, do we really know whether YouTube would have grown into some threat to Google? I don't know, right? Do we know maybe Google, we know Google invested a lot in YouTube. Maybe it was a great thing that they bought it because they took all this investment in servers and it took off and there were several other services and they just grew this one. I don't know the answer to that. These are deeply factually specific inquiries. There's a lot of uncertainty necessarily. You're not going to be able to look at these transactions in real time and have much certainty about what's going to happen. And you got to worry that the companies on the acquiring side, they can see around the corner further than the enforcers. Okay, so you got to worry about that. Okay, they can sort of see the threat coming, and you kind of think, well, they got a lot of money. Maybe if you throw some money at one of these things and you reduce the threat, you know, there's a lot of money in the bank account. Now, I don't quite think that way as an economist, but there's an element to that. So I think the problem, the issue in the end is going to be the legal standard. Think of, here's more like a current standard is, I won't get this exactly right, it's like, in order for the, let's say DOJ, it could be the FTC, to win a case on this, they have to show that the target company was an imminent threat to directly compete against the acquiring company in the foreseeable future, and there were very few other such threats. Something like that, okay? Versus another standard could be, well, if you've got a dominant position and you're buying a company that's in an adjacent market and has a reasonable prospect of becoming a competitive threat in the foreseeable future, then it's presumptively illegal, and they could reverse that presumption by showing there were efficiencies. Okay, so these are legal standards. I'm just telling you, in practice, if you're going to do anything with these deals, you're going to have courts and enforcers be willing to go after a deal where there's a lot of uncertainty. We don't know for sure. But maybe if we narrow it to firms that have a dominant platform position, or just a dominant position, actually, we should be tougher on that. You will get a lot of pushback, including by the VCs probably, but that's the other direction we could move. Neither of these directions are easy, so go on, do your regulation, get on with it. Thanks.
Babette?
First, I get to start. My privilege to start by saying I am with the FCC right now, and none of my comments here reflect the views of anyone in the commission or any of the commissioners.
I think they're having trouble hearing you.
Can't hear you. Speak louder.
I think help is on the way.
All right.
No, it seems to be on. You were
We need to move. I don't know.
All right. Can I talk really loud? It's just not on at all.
Not working.
Nothing like at the tech
platform.
place where we have all
Now
the
you're in
problems,
stereo.
right? Now I'm in stereo. Coming to you in Dolby Sound.
Very depressing,
So it's my pleasure to be here, pleasure to be invited, Phil, thank you very much. And it's my pleasure to say that I am currently with the FCC, and the views I express here are mine alone and not those of any of the commissioners or the commission. So that was fun. So it's been a great time here and a lot of great discussion. And I want to just jump right into Patty Limerick talking about the ebb and flow of corporate power yesterday. And it was fascinating. And I love that Carl started exactly there, and that we are in an antitrust moment. And we've seen these moments before. So we have this move to populism. So I don't think it's something in any way for an antitrust person like myself to not embrace. I think it's an exciting moment to think about these issues. And I think it's no surprise that it's coming at this moment, because the ebb and flow, as you can see, will often follow sort of a maturation of a new market, as Patty herself talked about, that it can be very exciting at first, and then you realize, oh my goodness, things are happening that perhaps we didn't bargain for. And in those moments, then we have to think about what are we going to do with those issues that are arising out of this more mature industry. And we turn to thinking about the law, legal restrictions, and we naturally turn, as you mentioned, to antitrust, that correlation with corporate power, and regulation as well. And with a hat tip to Gene Kimmelman, I'm going to summarize your statement as saying, Carl, antitrust is a very powerful tool well used for finite purposes. I think that was pretty much the quote he was looking for on this panel, so you're welcome. So as you correctly put out, is that in this populist moment is an opportunity for education, what antitrust can and cannot do. And part of that is because we are restrained by almost 100 years of jurisprudence. And so that's an important thing to talk about during the discussion. And it's an important part, and your article points that out well. So it's important, arguably, to keep in your lane what antitrust does well, because if you go too far afield, it becomes a little bit more difficult to catalog, and we saw those sort of definitional problems on other panels, especially when it comes to privacy. And I'm going to bring this in, and I warned Carl, I'm going to flip sort of questions at him and sort of scenarios, because there is this concern about data that came up in the last panel. In fact, I think the questioner even said we shouldn't even think of these as platforms at all, but as data companies. And data has this alluring connection with privacy, right? I don't think that they are strongly linked. I think there are different concerns when you're talking about what legal regime can handle what. I believe that privacy issues are best dealt with actually with some sort of legislation and not through antitrust. But that said, to the extent that data might have some competitive impact, let's talk about that for a second. So the conversation, you brought it in the EU, so let's talk about the EU a little bit. And a lot in the discussion groups of antitrust in the EU is dealing with data and the concern of just one company having lots of data, right? And what does that mean? And I think that's an interesting place to start. Are we just condemning them because it's big? What is it about that data? Is there something specific about that data? So just talking about data without context, I think, is like talking about other things without context. Is there a characteristic, a particular characteristic of that data or that data set that is concerning? That might be a bottleneck. That might be non-replaceable. Because when you think about it, data is actually personal data. My personal data is actually non-exclusive, right? I can give several companies my phone numbers. You know, they only call during dinner. But you can't repeat it. Now, obviously, there's you know, the argument that it's difficult and it's easier once you are good at accumulating data and there's a feedback loop, et cetera. But I think we have to be careful because we're hearing conversations bad about an old antitrust term known as essential facilities. You talked about duty to deal as well, and those limitations. So I think we have to have a good sense of what we're thinking about when what is the harm that having a lot of data has? Or are we talking about something else? Are we talking about non-replaceable data, difficult to replace, or the algorithm that processes that data? And enter the CFO of Germany, the president at the FCO, the Federal Cartel Office, did come out with this decree against Facebook, which was really interesting. And I'm just going to quote the president saying that as a dominant company, Facebook is subject to special obligations under competition law. And what they were doing is they're linking their platform now with their prior merger purchases of Instagram and WhatsApp. So it will be a seamless data. So any app, even if you're not on Facebook, but you're on WhatsApp, Facebook will have that data. If you're on Facebook, they'll just put it all into your Facebook account. So they say the only choice the user has is either to accept the comprehensive combination of data or refrain from using social network. Now, under what you already said, obviously this doesn't look like the exclusionary conduct that is isolating a rival that we're looking for in U.S. antitrust. This looks like those special requirements that we put on a dominant firm in the EU. So it looks more like this is a privacy issue, maybe an FTC issue, maybe it's a contracting issue. But then he said something else to the journalists. He says, and this looks more like it's a merger issue. And he says, the decision was a step in the direction of breaking up dominant tech companies. Quote, people always ask to break up huge internet companies. Well, what we do here today is really something like internally breaking them up. So really, it sounds like they have merger remorse in a way. And this might be a merger question. And could we have seen that coming? Well, they did kind of see it coming, but Facebook really promised that they would not do this. So, so there's a separate issue about that, about the, was that positive, was that a change of circumstances that should not be permitted, et cetera. So that's under investigation. What the Commission completely agrees with you, Carl, is it's not a privacy issue. So the European Commission, who's the competitive counterpart, even when they allowed the merger, they said any privacy-related concerns flowing from the increased concentration of data do not fall within the scope of EU competition law rules. Now, they do have a the GDPR, we know we have that, but we have the FTC, we have other privacy regimes existing, and perhaps we'll have legislation. So again, a recognition that there's a difference what the competition laws can do and what perhaps privacy regulators can do. So I just want to get back to that and thinking about data as we go to mergers. And one of the mergers that really looked at the characteristics of data of what we're actually concerned about is the Bazaar Voice power reviews, which I know you know. And it's an interesting one because it looked at the merger of two rating firms and basically that is unique data. Because it's the review. So even though they were small, so it wasn't perhaps a market share problem, but it did look at the data itself. So I do think that we have looked at data. We can look at data in the antitrust context, but this just a lot of data without a specific harm attached to it, I agree, would not be part of that jurisprudence. So I have some questions off of that, but those are my thoughts for your future comments.
All right, Jeff?
Thanks, Brian, and it's great to be up here with this panel. I feel like the guy who batted eighth on the 1927 Yankees. Does anybody remember who batted eighth on the 1927 Yankees? Exactly. One just brief disclosure, Google is a client. I advise them on antitrust issues, so take what I say with a grain of salt. The views I'm going to state are mine and not Google's. So I want to expand upon what Carl touched on about acquisitions, and in particular how one might, as a creative lawyer, begin to push the potential competition doctrine using existing law. And as Carl said, and I won't go on at any length about this, the case law is very narrow, and it's basically the flip side of entry as a defense in a merger, which if you're two merging parties, the regulators think there's going to be, the enforcers think there's going to be a problem. Did it just go on? I need to talk this way. I'll look at the enforcer. So then the parties may assert that another entrant into the market is going to offset the harm to competition, and that entry has to be timely, likely, and sufficient. That's the legal rubric that is used to uphold a merger that might otherwise be challenged because of a potential entrant. Well, conversely, if a firm with market power is seeking to acquire someone, the traditional case law looks at whether that target would be an entrant timely, likely, and sufficient to curtail the market power of the buying company, if you will. Now, I would suggest to you that, as Carl, I think, implied, there are other ways of looking at it insofar as so-called dominant firms are concerned. One of the challenges, because of the existing doctrine, is it's really constrained by the target's plans. It may be that the target, imagine Instagram in 2010 or 2011, for example, wasn't planning to enter the particular space of Facebook's. That might be a problem in bringing a case. Well, the advantage of the monopoly maintenance approach that was taken in the Microsoft case, if applied under Section 7 to mergers, I think is a good one. It does not one of the things, we talked a little bit about the case. Doug was the intellectual architect, I would say, and I learned a great deal from him while working on it. We did not need to prove, and the DC Circuit affirmed that we did not need to prove that Netscape was going to curtail Microsoft's operating system market power. It was a threat. It was a probabilistic challenge. That is to say, the browser may have commoditized the operating system, in Bill Gates' famous words, but there was not a finding that it would have. And that, I think, is an analogy that one can take to potential competition in acquisitions. Incidentally, by the way, Microsoft offered $2 million what's the guy, Austin Powers, at $2 million for the source code of Netscape in 1994. That we put that into evidence in the case. Now, Netscape rejected the offer, and the rest is antitrust history. Instead, Microsoft embarked on an anti-competitive campaign to crush them. But if you think about the potential competition doctrine as really the mirror image of the options that a monopolist faces at the moment when a potential competition threat emerges on the horizon, Bill Gates, one of the greatest businessmen of the 20th century, should have just offered $2 billion instead of $2 million. And would the government at that point let Microsoft buy Netscape, even though it was a potential threat to the operating system? So I think the rubric has some life. It also has some life because it helps overcome some of the market definition problems of traditional market analysis. Microsoft actually argued at trial that Netscape's browser was in the same market as the operating system, and we in the Justice Department argued that it was not and that it need not be. And Judge Jackson's finding in support of our position was affirmed by the Court of Appeals. So again, it helps to get around the problem of market definition. Another point here, as we've talked about the so-called consumer welfare model, which is going to be rebranded, I think, as the Shapiro model. It does not necessarily require a direct price effect or output effect. Although, as Doug eloquently explained, the Supreme Court is pushing in a different direction now. But again, in Microsoft, there was no finding that there would be a direct effect on prices or on output as a result of Microsoft's attempt to crush Netscape. And that rubric itself may be helpful in framing a challenge to a potential merger. Now, another point, this is a little bit off topic, but it kind of pivots off of what Babette was saying. If in looking at these potential market mergers and looking at the price impact, there are some who suggest that data is the currency that users pay to platforms for them to let us use the platform for free, for no dollar cost price. So another way of thinking of the potential competition problem is, would a merger effectively increase the merging firm's ability to extract data, therefore raise the data currency price of the merger? I offer that as a thought. Now some just modest things that one needs to think about. Tim Bresnahan back in the 90s and others since then have written important papers about where does competition come for a dominant platform. It typically does not come from a direct head-to-head competitor. It often comes from somebody who invades their space from an adjoining space. So as we're thinking about potential competitors here, I think it's important to kind of understand which platforms might make an acquisition and to distinguish among them in context. It's important not to generalize here. I would submit, and again, they're a client, Google buying Android back in 2005 for $50 million is different in 2005 from Apple buying Android. Apple, of course, had developed, although not launched, the iOS operating system for the iPhone. So Google bought Android to enter and, in effect, compete with a firm that was on its way to great success, if not dominance. Apple buying Instagram, counterfactually, would have been different from Facebook buying Instagram. So I think which platform you're talking about in each context matters. So some suggestions for the enforcers, and we're blessed to have a couple here today. I think the HSR thresholds are a challenge here. Bazaar Voice was talked about as a data merger by Babette. That fell below the HSR threshold and was a case that was brought without the benefit of a front-end investigation prior to the merger. I think what you really need to look at is the deal flow. Now, Hal made the point yesterday that a lot of Google's acquisitions are employees of 2 or 3 people, and so I think looking at every deal would not be right and would not be efficient. But I think that the agencies need to understand what the plan is. That's observation number one. What is really going on in the acquisition strategy in these firms? That's thought number one. Thought number two is you've got to ask yourself what role price plays in the transaction. Price can be a terrific indicator of complementarity, right? That the firm that's being bought is a uniquely complementary asset to the acquiring firm and not to others, and therefore the acquiring firm would necessarily pay more for it, right? On the other hand, price can be also consistent with an anti-competitive motive, because if you're paying a supra-competitive price, that may mean that you're trying to protect your position from a dominant entry. That bears a lot of study, in my opinion. One more, which is, I think that it may be harder for a firm to achieve scale than it is once it has achieved scale to add features that compete. So when we look at mergers that are made by dominant platforms and they're buying companies that may have scale, I think that is even if it's in a much separate space, scale implies ease of distribution and perhaps ease of taking up the services of the acquired firm. If the acquired firm with its scale were to go into other hands, the question is how easy would it be for that firm to mimic the services of the dominant platform? And if so, are they uniquely well situated to offer those services? So that's kind of a brief tour of the horizon, how one might think about potential competition going forward.
All right, Jeff, thank you. I think with that, on that note, we're going to bring Doug back in to talk about transactions, and we'll let Carl defend some of the assertions.
Just a couple thoughts about what are sometimes called killer acquisitions, the ones that Carl and Jeff have been talking about. I completely agree with Jeff. I think he's just right on that in effect we should be thinking of this more as a monopolization problem than a merger problem because of the very difficult merger doctrine that Carl referred to. Just want to add a couple of thoughts about that, and I want to put it in context. Look, U.S. antitrust law conceptually is really very simple. There are two elements, right? Anti-competitive conduct, namely conduct that's not efficiency-based competition on the merits, and a resulting increase in market power. All antitrust is about that. So let's look at these mergers. You could look at anybody's merger Google's acquisition of anybody and say, well, you know, that reduced the probability that there would be entry in my space, erosion of my market power, doesn't that begin to create a competitive problem? So I think you have to add the second element, which is there bad conduct here? And I think Jeff got most of the way there when he talked about the role of price. The way I would look at it is this. Facebook buys Instagram. What price did it pay? Does that price make business sense if you look at Instagram simply as a way of increasing the profitability and the value of Facebook without regard to reducing competition? It brings a new asset. You know, it's like an automobile manufacturer that buys somebody who can give it a better transmission than it could otherwise make, right? If they're paying more than that, then they're probably taking it off the market, taking it away from people who are willing to pay simply for its economic value, taking it off the market because they're trying to reduce the probability that it would facilitate some kind of entry that would erode their market power, and then you ought to say it's illegal.
When you look back across the approval of acquisitions for internet platforms over the last 10 or 15 years, where was the mistake? Have there been mistakes you would say that they shouldn't have done that one?
Well, I don't know the facts of these transactions enough to answer that with confidence. But there's an ambiguity in the question I have to clarify. Looking back in hindsight, I think most people would probably say, if I would at the casual newspaper level, Instagram, Facebook was a big mistake. But the problem is, was it a mistake given the information and the tools available to the agencies at the time? That's a much, much harder question. And I think there's some potential here in what Jeff is saying, with my amendment, for a way to help focus the ex ante, if you will, inquiry in a way that might help the agencies make the right decision, even under conditions of uncertainty. Oh, just one other thing. Huge amounts of U.S. antitrust doctrine reflect a judgment about the relative risk tolerance we have for false negatives and false positives. Well thought through, it's an important component of antitrust doctrine. But we might be thinking, in light of the changed economic circumstances, of recalibrating that judgment a little bit and increasing our tolerance for risk of false positives in exchange for reducing the risk of false negatives, and that too might help the agencies get to the right result in some of these cases.
Carl next, and then the students should be getting ready with a question or two coming up.
Let me respond briefly to both of you guys. Babette mentioned the concerns about data and the importance of data. So I think, look, there's way more data available and accumulated than there used to be. And there's a complementary thing, data processing, artificial intelligence, machine learning. So data is just, we all know this, it's hugely more valuable, and therefore it can be a much bigger element of competitive advantage, okay? Competitive advantage is always about what assets does a company have that others don't have and can't replicate easily. It's always been that. So I have a bit of a caution. Well, one way to think about it is, what do we know about accumulation of such assets? How have we treated them historically? Even though it wasn't data, it's still an asset. Back in the days of aircraft manufacturing, the learning by doing, the experience curve, that was developed after World War II in aircraft manufacturing. That's a big advantage of an incumbent. It's a form of scale economy. In Microsoft's case, it was about the applications barrier to entry, which was network effects, indirect network effects, and how if you had a large platform, you'd have more applications on that platform, and that was harder for a small. So we've been through this before. In terms of specific data issues, I was involved in a case in the financial sector where there were certain codes used to trade certain financial instruments that were, I guess, copyrighted, but other people couldn't trade them because the owner of these said you can't trade them because it's a copyrighted, just a bunch of numbers or codes. So we got cases where the data is like, really, can you control a whole market based on some copyrighted data? And the Europeans have actually mandated sharing of data in cases where we haven't. Again, a difference. We're talking now about huge amounts of data and ability to process it. That's a source of competitive advantage. I think that's firms are going to compete on those dimensions. I think it's going to be very difficult, short of regulation, to mandate the data sharing, even before you just under antitrust, before you even get to privacy issues associated with that. So that's data. Jeff, I want to wholeheartedly embrace what you said, almost all of it, I guess. I would say my comments were slightly deficient, only slightly, because I really was thinking more about Section 7 and not so much Section 2. So, and Doug, you picked this up too. So I think that's, to me, an interesting line for the lawyers and I guess economists to think about too, and hopefully Macomb Delarine and Commissioner Chopra and so forth, about could some of these acquisitions be handled through essentially maintenance of monopoly, is how I would think of putting it in Section 2, which is you've got a monopoly, a dominant position, you're maintaining it by picking off or acquiring somebody who's a threat. And what the standards are for that, what we get from the Microsoft case maybe, I think that's a promising way to go, probably more promising than maybe Section 7. It is particularly since, and I want to echo what Tim Bresnahan's work on, he called something like divided platform leadership, some notion like that, which was often, if you really see the attacks to dominant platforms, it's not usually a frontal assault with a Me Too product. It's somebody in an adjacent space who builds scale, gets customers, and then adds features. That's one of the great things about software. It's very malleable. You can add features. So if you think that's how real competition is going to occur over time in these areas where it's hard to attack the fortress, then these are the very acquisitions you also need to be concerned about. I'll end, though, on a cautionary note about that, which is, I think, maybe, Jeff, you said, it depends a lot on the plans of the target company. Somebody said that. There's a real issue about evidence, which is, even under a Section 2 theory, if you have to show, well, this company had plans to come and attack the dominant firm's market position versus, no, they're just minding their own business, developing this thing, and maybe they would go in that direction later, but there's no specific evidence of that. Will that be enough to have a case like this? And to what extent can then the lawyers tell them, don't write that down because you might want to get acquired? So it's tricky.
So
Jeff is eager to jump in.
Just two clarifications. What I was saying is that's a limitation of existing potential competition doctrine, is that it looks too much at the target's plans. I don't think the approach that I was outlining is as dependent on it, for the reasons I described. Second, and this is a lawyer's point, forgive me, remember Section 7 is acquisitions that may substantially lessen competition or tend to create a monopoly. Those words are in that statute, and I would submit that one could read into that, create or maintain a monopoly, and in so doing, read in the Section 2 jurisprudence on monopoly maintenance into Section 7.
Doug, I want to pull you back in to talk about the Amex case again and talk a little bit about how you think the lessons of Amex, both in terms of what the court did and what you think they should have done, play out across an internet platform assessment or an ISP as a platform. How do we think about the transaction platform precedent playing out on other platforms and other potential two-sided markets?
Well, I mean, obviously the particular legal issue that might arise in a different case could be a very different issue from the kind of thing that arose in the Amex case. What I was focusing on was, I thought, an attitude of the court. It was not, it ignored facts, it was ideological, and it was largely driven, it seemed to me, sometimes explicitly, often implicitly, by these, what I called factual propositions from the 70s that really haven't stood the test of time. So I think the short answer is, my worry is that the court will be closed-minded and will use thinking that made perfect sense 40 years ago to deal with new issues like the ones we're just talking about, these acquisitions, that really require what Judges Williams and Ginsburg and their 7 colleagues did in the Microsoft case, which is to sit back and say, wait a minute, maybe the cliches of yesterday aren't the answer. Let's think this case through on the facts and come up with what I view as a magnificent decision and opinion. We need that kind of thinking in the Supreme Court, and I didn't see much evidence in Amex.
I think it's ironic. If you go back to some of the original Chicago School scholars, what they were saying is we need to understand how markets work and how the real world works, not some of what the court was doing actually in some kind of oddball decisions in the 60s. Okay, so I wish the Supreme Court was following that tradition. The Amex decision, while it's about payment systems, I think has direct and important implications for internet platforms, the topic here. Because it's very, let me put it this way, it's very hard it's easy to see how these internet platforms have two-sided aspects. We talked about Uber as one example, but certainly, basically any advertising-supported model, you've got the advertisers and you've got the users. Okay, so just to start with. Now, the court attempts to say, oh, no, this is just about these transactions, whatever the mark. But this is one of the, it can't, that's not, so I don't know why they wrote it to try to pretend it's narrower. That's completely unsustainable, okay? There's no economic distinction between that and many of the other platforms we're talking about. So I don't see how that could be sustained. The lower courts will look at that. They won't see differences. Eventually maybe they'll get to the Supreme Court and they'll say, well, yeah, it covers this too. I don't know. But there seems to be those who say, oh, don't worry that much about the decisions. It's very narrow and it's just these simultaneous transaction markets. I don't think that can hold up just logically. And if you want to know more about the decision, read Breyer's dissent. He just eviscerates the majority opinion on multiple. It's one of the strongest things he's ever written. It's very powerful, and it's sad that that's the dissent.
Just one point that came up in Doug's presentation on Amex that I wanted to ask you about, Carl, is you talked a lot about the distinction between what antitrust should solve versus what regulation should solve. And in the net neutrality context, of course, the FCC originally said no two-sided markets as a prophylactic regulatory decision. And then now it's reversed that. But do you think that the problems of two-sided markets in places like ISPs is better addressed through regulation or through the antitrust laws?
Well, I guess it can depend on the particular problem. A lot of these things, like I already said, a lot of the stuff is going to be about regulation. I also think, look, the people who say market should be one side or the other, Michael Katz testified for DOJ in the case. He said, look, of course you've got to consider when you think about the effect on the merchant side, what's going on the cardholder side. It's part of the strategy. It's part of the economics. He wasn't ignoring it. The question is whether by first ignore the direct evidence, throw away what the court had found below on the facts. Then when you're doing the first step of the 3 steps under the rule of reason, burden shifting, whether you have to go in this direction and build all that into market definition. And that's just, for all the reasons Doug said, doesn't make any sense. But I still think a lot of this stuff, look, if anything that's getting close to a duty to deal is going to face very rough sledding in antitrust. You look at the Trinco decision, there's just hostility to that, for better or worse. I don't love opposing duty to deal because it gets towards price regulation. So I'm just saying that then leads us into regulation in the United States.
Open it up for some questions. Start with a student.
Hal,
you're a permanent student, but you don't count in this context.
He's a student for life, I can tell you that.
Jordan.
Jordan Regan, I'm a 2L here at CU Law. Doug, you mentioned that when evaluating a merger or an acquisition, we would look at the price that the acquiring firm is paying. And based on whether or not that price is significantly above the market price of the acquired firm, we can make the determination that they are buying this firm in order just to scoop it up off the market and prevent it from being a potential competitor. Hopefully I didn't mischaracterize what you're saying. I guess my question is, how do you draw the line there, and how do you determine whether or not they are the higher price they're paying is to avoid any sort of bidding war and a potential competitor scooping up this company, as opposed to just eliminating the company from being a potential competitor?
It's a good question, and partly because it makes clear that I wasn't clear. I didn't mean, did they pay more than the market price? What I meant was, and this is a difficult question, I was just thinking sort of out loud about how you might sort of adumbrating the beginnings of a theory here. I was saying, look, it ought to be open to the Google or the Facebook, whoever the acquiring firm is, to say, wait a minute, this was a good investment for me for reasons that had nothing to do with raising entry barriers or harming new entrants. It was a good investment because I can persuade you that I have a path here to use these assets in a way that will increase the value to consumers of my product. So the question is the price higher than the amount that can be justified that way? Then you begin to say, this doesn't make any sense except as a way of buying insurance against new competition, and that's when you can say it's illegal.
Can I just add one thing? I mean, I think there are really two things going on. One is the degree of complementarity, you know, how much it will increase the value of the acquirer's business. The other is one could almost invert predatory pricing, the predatory pricing analysis. You'll recall, Jordan, since you were in Phil's my antitrust class, that when you're looking at a predatory pricing case, the question is whether the firm engaging in the low price can only recoup its investment, its foregone revenues, as a result of the damage to competition. The argument here would essentially be the same. You look at what the model is for the transaction, what are the anticipated revenues, and on a present value basis is the only way to recoup your investment through something other than the enhanced revenues that come from the complementarity and not from the harm to competition. I think you also, just as an empirical matter, have to look at the auction. That is to say, typically in these super high acquisition prices, there were other people sniffing around, and I think that those are helpful data. They're by no means determinative, but if it's orders of magnitude above what anybody else might pay, including someone who might pay in order to compete with the acquiring firm, you're going to look at that, and that's going to go into the calculus that you described.
Okay, Hal?
Okay, I don't have a
Microphone coming, and then we'll come down here.
I wanted to talk just for a minute about the data portability issue, because as you saw yesterday, we provide a lot of tools that allow people to extract their data, and now tools that even allow it to transfer it to other places. But there's two kinds of data. One is the user data, where I think the user has to affirmatively agree that their data could be transferred somewhere rather than slamming it. But the other side is the web data. And nobody ever talks about that. But that's, of course, free. Anybody can write a crawler, go out and crawl the web. The really costly part comes in taking that raw data and organizing it in a way that's useful for answering the search queries. So that's what we call the transfer of data into information, where we've made something that's useful out of this raw material. And I've articulated what I like to call the Porsche principle. You can have your pound of data, but not a drop of information. Because the information is what's generated by all of that investment in building a system that can perform as a search engine is supposed to perform.
Comments?
I do not believe that was a question.
It was hard to find out in there, but do you have a question down here? Yes, you did. Microphone coming, I think. Sorry, yeah, we're going to get you. Mr. Bennett, you're next.
I had a couple questions, but I think that I'm not an antitrust or anti-competition lawyer whatsoever, but it seems like the question about sort of what is it that we're trying to prevent, like sort of what's the harm, and I feel like the sort of traditional, someone said something about not necessarily maybe getting away from the term monopoly idea was like, well, we don't want to have just like one vendor, one grocery store and everyone has to go to the grocery store, we want competition. But I think we aren't in that world anymore. We're in a world where these companies that make us cringe because of their quote unquote dominance, I think they make it what's cringy is the vertical they create, right? The vendor lock-in, right? They're all competing to have all of your digital services in one vendor. So Apple wants, Apple's always been called the walled garden. So they probably maybe they were the kind of original, make it so easy to use all of their hardware. And now they want to be in your home, and it's really, the switching cost is really high, right? And then, you've got you can see that the table of all where they all compete, the big company, is a great example of that. They're diversifying. And so I think when companies, I know from my own experience, when companies buy other companies, sometimes from the outside, you're like, why are they buying that? And so the reason they're buying it is because they're trying to create, I don't want you to just come to me for X, Y, and Z that I'm good at. I want you to come for me I want the whole ecosystem. So how do we, is there some space there? And I think the idea of portability, software interface, it's all about software and services. So maybe is there room for a regulation that isn't necessarily anti-competition as much as it's about software interoperability and requiring that, make it harder to have the full vendor lock-in on the vertical and or to have, as a user, to have more control over where you have your data and not necessarily being locked into having it all with one company? That was my first question.
Well, I'll give a short response, which is the traditional, this issue more generally in antitrust has been about firms with full product lines competing against firms with narrow product lines. Okay, it happens a lot in healthcare, for example, and if customers want one-stop shopping, that gives an advantage to a firm with a broader product line. So that's the more abstract formulation, if you will. It's a very good thing if a bunch of the firms are all competing against, so they all are offering these pieces. So maybe if you have 4 or 5 who are offering the full line, maybe that's pretty good. But from an antitrust point of view, you want to make sure disruptive entrants, smaller firms who want to just offer one piece can do that effectively. And that may require regulation if it means some sort of interface.
Are there lessons from the telecom side that you would draw in thinking about that problem?
I think that's a fair characterization. And when you come to that, what are you talking about at the sort of backstop roles? Like the ability for me to get on there. Is that something that we want to make sure that we have? So that I can have my app or whatever. So that would be something that regulation might do. Now, we have seen things like that deal with access issues and historically bottlenecks in telecom, famously in landline phones. And I think it expresses the difficulty of antitrust doing sort of what's known as an essential facilities doctrine or duty to deal or something like that, when they're identifying something that is difficult to replicate because of scale economies, whatever, because the antitrust authority then comes in and they suddenly have to say, well, you have to give access, but then there has to be follow-up conversations. At what price? And so you become, it's very difficult and very complicated to become then the price regulator. Now, the FCC has been the price regulator. And even then, as a regulator who knows it, it's difficult. They were invited after the 1996 Act to identify important equipment and allow competitors to come in to sort of add competition to the local telecommunication market. And they had difficulty doing that. Their first time, they basically said, well, all these sort of parts and the whole thing as well. All of them are essential, and that's in the Uni and Uni-P. And so the Supreme Court actually slept them down, I think it was Breyer actually, and said, no, that's not what we mean. It really has to be necessary. It really has to be non-replicable, and that's important for competition because we know in telecom that it's much, we get very aggressive, more aggressive competition, arguably, when we have facilities-based competition. So rather than people squabbling about prices. So they had to go back and they had to really identify what is essential and what are those rules. And it was hard. It was very, very difficult, and there might be a judge in the room who knows a little bit about that.
Just theoretically.
There just might randomly be someone who needs to come up and talk about that, about how difficult that was. But in other words, it's complicated. If it's hard for the regulator, it's very hard for the antitrust people to do that well.
And would the essential facility essentially be here the data, the personal data that drives the advertising?
I'm sorry, what?
What would be the piece?
It's hard. People talk about data very, very loosely. I think, Hal actually got at what I think might be what people are more concerned about is not the volume of data, but the ability to process that data in a meaningful way that perhaps scares us, like that perhaps feels like someone's watching us. And that's really, obviously, the data is an input for that, and it's easier for them to develop the algorithm, but I do think that pinpointing what we are concerned about is more than just saying personal data. Now, just saying personal data might have impact for concerns, privacy concerns, right? But that's a different story. That's a different conversation.
All right, I'm getting the high sign on that note. I think we're going to wrap up. A round of applause for our great panel. It is my pleasure to turn it over to Mr. Weiser, General Weiser, who's charging down here somewhere, coming through the door right now. There you go.
All right.
Actually worked with 3 of the people on this stage here. And here we are, and we have another Assistant Attorney General for Antitrust, someone who is an honorary Coloradan, having worked with a law firm founded by a number of the graduates of this law school. Like myself, he has had 2 tours of duty in the antitrust division, previously served as a Deputy Assistant Attorney General. He also worked in the legislative arena, including for Senator Hatch at the times that some of the Microsoft issues were being talked about, that you heard talked about here. And we've asked him to kind of give us our closing address, which is, as Carl Shapiro noted, fitting, because so much during this conversation has been, what's the role of antitrust law? What's its future direction? He's going to talk for, I think, 20-ish minutes, we'll see, and then take some questions, and then we can continue visiting over lunch. So without further ado, Macon, take it away.
Thank you.
Thanks, Phil. Thank you so much, Phil, and for inviting me in Silicon Flatirons to come back here again. I love what you've done with this program. I think for the students, Phil is an absolute treasure, and you guys are lucky. And you know his passion for the student. And his, I think, long-lasting legacy, in addition to his public service, will be the future leaders that he will have had an influence on and creating, including perhaps, as he mentioned last night, hopefully a future Supreme Court justice and Attorney General, like the old Attorney General from Missouri did. Let me also just at the outset congratulate you on your election as Attorney General of this great state. I very much look forward to working on the important issues that you and I both care about, protecting competition for the benefit of consumers. I should say, I was debating whether I was going to say this, but I think it's appropriate, particularly a great judicial scholar, Judge Posner, you might recall, at the Great Hall of the Justice Department about 15 years ago, said that, let me say that I don't agree with his comment before I say it, nor do I agree with much of his jurisprudence towards the end, especially about judging. But he said that state attorneys generals are the barnacles on the ship of antitrust enforcement. So I actually think you're going to be the turbo thruster on this ship of antitrust that has been added, and I look very much forward to working with you and your other colleagues. I've really enjoyed the presentations the last 2 days, especially this last panel with a lot of my friends on the panel. Let me just quickly say a couple of things. It's really hard to disagree with Doug about the criticism of the American Express case. I don't 100% agree with it, but I do. You know, it's a perfect example of sometime bad cases making bad law that will create real problems. And unfortunately, I think this will lead to a lot of litigation. I think the Second Circuit 100% got it wrong on market definition. And sometimes when you tee up a bad case, and in that case, not distinguishing between a four-part Amex, four-part system of the transaction model between Visa and MasterCard versus the fully integrated three-part system that Amex did to try to really break up that system for over 20 years is the perfect example, but without criticizing my colleagues, but the district court got it right, and I think they should have gotten a lot of deference for the harm that they found. The brief that the Justice Department put in as the amicus, which the process is interesting given that it was a DOJ case, but participated as amicus ultimately in the Supreme Court, since Ohio was the AG that brought a petition for cert. I stand by the test that was put in there, and it largely followed a lot of the guidance that Doug mentioned as far as looking at the two different markets and a two-sided platform, the interrelationship, how you define the market from an economic standpoint, and Justice Breyer largely adopted that. And I actually think on remand, Amex's practice probably would have survived that test, especially with that panel, and we wouldn't have been where we are. Fortunately, the Supreme Court, and why I'm not as anxious about it, is that I think it puts some interesting limiting principles in there that it won't apply. But that's going to be great news for a lot of the students here, because that means there's going to be a lot of litigation on it, as well as a lot of corporate maneuvering onto how you shoehorn a transaction in order to try to seek the benefits of what the Supreme Court said. But it's going to be a little bit of a mess to figure out what it really means on two-sided markets. With growing attention on the policy challenges posed by today's large tech platforms, as this conference has demonstrated, often comes up within this broader debate on the role of antitrust in today's digital economy. I've touched on a number of topics in this area in past speeches, including innovation, data, and how you properly should treat data, which addresses some of what Hal raised at a University of Haifa speech recently, privacy, consumer welfare standard, and certain remedies. I try to do my best not to repeat past comments, and today I'm going to focus on a different and a related issue that is relevant to both platform and the digital economy. And that's how antitrust enforcers should think about free, or probably more accurately, zero-priced products and services. There's a whole forum at the OECD talking about whether these free products means that we have to change our antitrust standards, and a lot of presentation by very smart folks, which made me think maybe we should talk about it. And bear with me as I go through some examples of markets where we have seen and have had some practice in this area. So the title of the speech, and some of you know I like to put some of my favorite songs or songwriters as the title of the speech, and this one is I'm Free. I'm Free is the popular song, still popular song by the Rolling Stones that was written in 1965, just a few years before both Phil and I were born, but more importantly, just a few years before the DARPA project by visionaries Bob Taylor, Vint Cerf, and Bob Kahn, who actually invented what we know today as the internet. And the song tells us, and more importantly probably tells Mick Jagger, that we're free to do what we want any old time, and free to choose what we please at any old time. In today's digital economy, consumers too can choose and do an increasing number of things for, quote, free at any old time. They search online, they connect via social media, play games, write emails, read the news, listen to music, make reservations, get directions, track your fitness, and a whole host of other activities without paying a penny. Some of them may be productive, some of them are total suck of good productive time. Yet, are these services really free? As an aphorism often associated with Milton Friedman goes, quote, there is no such thing as a free lunch. Most firms that provide goods at a price of zero are making money somewhere else, either through different products, different consumers, or at a different point in time. Consumers also typically exchange something of value, such as their attention to advertising or their personal or usage data for these free services. So when we talk about the digital platforms providing free services, we're really talking about business strategies where zero is the chosen profit maximizing price. Setting a zero price ultimately can make those firms more money. At least that's what they hope, by, for example, incentivizing balanced participation in a platform, by driving up demand for a complementary product, or by helping them break into a whole new market that's been dominated by certain incumbents. Zero-price strategies have exploded in the digital economy, driven in large part by the Internet's decreased production and distribution costs, and the increase of digital platforms characterized by network effects and the economies of scale. We should remember, however, that the strategy of selling a product or service at zero price is not new, nor is it unique to the digital economy. Let's start by taking a look back. Radio, broadcast television, and newspapers, all forms of ad-supported media, existed long before the rise of the digital economy, with radio going back to the 1920s. And audiences have long enjoyed many of these products and services for free, funded by advertisers. Let's look at some different types of zero pricing strategies. Not only do zero pricing strategies predate the digital economy, they also are not all the same. There are several types of zero price strategies which vary depending on the industry and the context. These differences are important to antitrust analysis. Determining how a firm profits, either today or in the future, from zero price strategies can shed light on whether conduct in these contexts could raise competitive concerns. While the antitrust laws are not subjective, looking at a firm's motivation in some cases can be a helpful starting point. Why has a firm chosen a zero price strategy? Is it a predation attempt to exclude competition and ultimately raise prices? Or is it a strategy to achieve optimal and balanced participation on a platform? Or is it a temporary effort to break into a new market and actually increase competition? Many multi-sided platforms, especially in the digital economy, follow a zero-price strategy. Ad-supported media is a leading example. Platforms provide content or other services for free to consumers and make money by selling the attention or information of those consumers to advertisers through ad networks and other means. As such, the users actually become the input of the product that's ultimately sold to the advertisers. They are not necessarily the customer that this product is designed for. Platforms use a zero-price strategy in a variety of contexts, both online and in traditional industries, such as online search, social media, email, broadcast TV, and radio, as I mentioned. Exchange platforms that connect groups of buyers and sellers like eBay or OpenTable also use zero-price strategies. In order to strike the right balance of buyers and sellers, platforms may decide to charge only one side of the exchange for its services. Traditional shopping malls, as well as digital marketplaces like eBay and Etsy, typically are free for consumers to use, but charge the merchants to participate. Restaurant reservation apps like OpenTable and Resy provide just another example, allowing diners to book tables for free while charging restaurants in some of those models. And it's an important area and market just in this restaurant reservation because different business models are experimenting specifically in this reservation industry. And the jury, I think, is still out as far as which model or models will ultimately succeed. There was a good paper written about this a few months ago and showed the different market entrants and some of those who have not succeeded and how and which way they actually support the restaurants. Transaction systems such as payment cards also must balance user and merchant participation. As the Supreme Court noted and Doug talked about in the recent American Express versus Ohio case, quote, to optimize sales, the credit card network must find the balance of pricing that encourages the greatest number of matches between cardholders and merchants. In some cases, that chosen optimal balance leads to setting the consumer price at zero or even below zero when you count in loyalty prices and free loans with merchants paying a fee on each transaction. Another zero-price strategy is to tie or bundle a free product with a complementary or related positively priced one. This strategy can be profit maximizing if the offer of a free product increases demand for the positive priced good. For example, cell phone service providers may offer a free phone with the purchase of a certain service plan. Another is perhaps Gillette's strategy of providing consumers with free razors, hoping it'll create brand loyalty and lead to future razor blade purchases. This area of bundling obviously is a much more complicated and complex one, dealing with perhaps anti-competitive effects. And there was a famous case in LePage's that we can teach a whole semester class on about what that is, and I think that's an area still in flux as far as loyalty bundling and where that is. Another strategy is where businesses provide a basic service of their product or service for free and a higher quality version for a positive price. This premium upgrade or freemium strategy attracts consumers to test out the free product with the hope that some consumers will upgrade to the paid version. The sale of the premium product, often to a very small fraction of the users, subsidizes the provision of the free service to everyone else. That's examples of that are Adobe, Dropbox, perhaps Spotify are some of those. Firms also use a hybrid strategy, offering the free ad-supported service and a positively priced service premium version. Music streaming services like Pandora and Spotify are examples. And one of my favorite new discoveries is Amazon's new IMDb free dive service, which at least for now is offered on multiple platforms, including Apple TV, which is what we use. They just started last month, and they're offering and giving the consumers the choice to watch premium movies that otherwise are not available on some of their subscription services with ads inserted in them rather than renting it on Amazon Prime or on Apple iTunes. Again, a brand new model that we will see how it survives, but ultimately it's giving consumers the choice, and we'll see what wins. Finally, businesses may temporarily offer zero-price products or services to promote their brand or break into a new market. In such cases, a firm will lose money in the short term in order to attract customers with a hope to turn a profit in the long run. In the digital space, platforms also may offer a new product for free during its beta testing phase to help measure consumer demand and improve the product before its official launch. A number of products actually started in that way, including Facebook. Some of us may also remember the AOL discs sent in the mail for 50 or 100 hours of internet access. I'm sure a foreign concept to a lot of the students in this audience, but a lot of us remember when the internet was first beginning. That's how they gained some market share. A less benign zero strategy is to provide a product for free in order to drive out the rivals from a marketplace, and then recoup the cost through monopolistic prices at a future date. Predatory strategies, however, are not always successful in practice. Once consumers expect products or services to be given away for free, it can become hard to impose even a small positive price. For example, a study, which I should note we have not scrutinized, estimated that 84 to 87% of respondents would leave Facebook if it started charging $1 a month. We should also distinguish between penetration pricing, which can enable a new entrant to challenge incumbents and is at the heart of competition, and predatory pricing. So let me talk about some of the benefits of zero-price strategies. Consumers benefit from these strategies in a number of ways. These strategies bring goods and services to consumers who otherwise could be priced out. Consumers can exchange their data or attention in lieu of the money to receive valuable services. Some studies, again, demonstrate that many consumers prefer ads to paying for certain services. Just last weekend, I could be a single subject study where I was going through Apple iTunes because my kids wanted to watch a certain movie, and then I checked Amazon Prime. Both of them would have required me to pay $4.95. I was too cheap. When I checked on the free dive service, the same exact movie was there, and I chose to do that with a little pain of watching, I think it was 3 ads that were inserted in. In the study that I mentioned a bit earlier, 79% of respondents represented that they would choose an ad-supported Facebook over paying $1 a month. Another study found that consumers almost always choose free and ad-supported apps over the 99-cent alternative without ads from the app stores. For now, consumers seem to be willing to provide information about themselves so that they receive the product for free, even recognizing their information will be sold to advertisers in exchange for a zero price. Some consumers even may prefer receiving targeted advertisements that are more likely to be relevant to their needs. When I say for now, means there are some consumers who are beginning to question that and question whether or not their data is being misused, and we might start seeing revealed preferences there. Zero price strategies also may enable new entrants to break into markets, increasing consumer choice. Firms often compete with these strategies on quality and innovation, which can also benefit consumers. Competition on non-price factors often leads to product differentiation or hybrid strategies to appeal to different consumer preferences. For example, consumers may choose between radio stations based on the amount of advertising or based on the quality of the content and the offering that they have, or choose online search services based on more accurate results or greater privacy protections. Consumers could benefit from a free market that gives them the ability to choose between these different business models. Of course, these choices can lead to, as I mentioned, so-called revealed preferences, should consumers begin to value their privacy differently. One goal of antitrust enforcement should be to enforce the market, that the markets are free for competition by such new business models. In addition to their many benefits, zero-price strategies also pose real challenges for antitrust enforcement. In the absence of price competition, market definition can be difficult. The traditional analytical test applied by enforcers to define relevant markets, or the SNP test, which looks at small but significant and non-transitory increases in price, does not translate directly to a zero-price market. We cannot look at the effects of a 5% increase in price, because 5% of zero is, of course, zero. Choosing variables for measuring market share also can be more complicated, where shares of revenue is not an option. In light of these challenges and the increased prominence of zero-price strategies, many currently are debating how antitrust enforcement should treat such products and services, especially when offered by a large digital platform. On one end of the spectrum, some argue that zero-price products and services should be exempt from antitrust scrutiny. They argue that consumers and competition cannot be harmed if users are getting a product for free. Doug and others remember that this is an argument Microsoft used without much success in the DOJ's case against them in 1998, both, I think, in the district court and in a unanimous DC circuit led by a lot of great judges, including Doug Ginsburg, the former head of the Antitrust Division. Some argue that the benefits of free products and the complexity of the antitrust analysis should lead us to forego antitrust enforcement in this area entirely. On the other end of the spectrum, commentators and some foreign antitrust enforcers call for more aggressive enforcement efforts against digital platforms that provide free services. These commentators and enforcers consider the collection of consumer data in exchange for products to be potentially anti-competitive. Some even propose throwing out the long-standing consumer welfare standard and crafting new rules to address these businesses. The long history of zero-price strategies teaches us, however, that both of these extreme views are misplaced. First, we should not exempt zero-price models from antitrust scrutiny and give a free pass to free services. U.S. antitrust laws apply in full force to zero-price products and services. For example, agreements among competitors to allocate markets or customers are per se unlawful, even in the context of zero-price goods. Naked horizontal agreements to fix levels of non-price competition, such as quality, advertising, privacy protection, similarly raise antitrust concerns. We had a recent enforcement action dealing with radio and broadcasting in exchange of pacing information. Mergers to monopoly and certain tying arrangements could also violate the antitrust laws in cases involving zero-price strategies. In fact, the Antitrust Division has reviewed conduct and mergers in zero-price products before, such as broadcast television, and we continue to do so. The argument for immunity ignores that these firms still compete on non-price dimensions, and the zero-price products are often intertwined with other positive price products and services. And as such, firms with zero price strategies can still engage in anti-competitive conduct, and antitrust enforcers must stand ready to protect competition and consumers. Indeed, public enforcement of the antitrust laws may need to play an even greater role in zero price settings where the absence of price to the end consumers could make private damages recovery difficult, or where effects on business partners, such as advertisers, who must rely on ongoing business relationship with those platforms, may impede the incentive for private antitrust actions. Second, our long history with zero price strategy tells us that we do not need a wholesale revision of the antitrust laws, and Carl Shapiro in his paper and others explain that and explain why. Our laws are flexible enough to adapt to the challenges of the digital economy. The standard is not limited to looking at price effects, as some have argued. It also takes into account effects on quantity, quality, consumer choice, and innovation. With zero price goods, it simply becomes more important to focus on these other non-price factors for us, or to focus on actual consumers who really pay for the service. So, as I mentioned, one of the challenges for antitrust enforcement in this economy is that it often can be harder to define the relevant antitrust market. Traditional economic tools that rely on measurements of price are not available for the zero price context. What then should we do in defining markets and assessing market power in a zero price economy? As a starting point, we must not fall into the trap of believing that because there is no price, there is no market or market power. At the same time, we must avoid the temptation of defining markets with subjective definitions that shortcut rigorous analysis. We should not simply apply labels to a market without looking at the real-world competitive dynamics. Nor should we simply simplify the analysis by defining the market by the identity of the platform providing the product. We need to look at the facts of the specific case and the effects on competition. Second, for zero-price products and services, a proper antitrust analysis often requires looking more broadly than the free product itself. Remember, for-profit firms that use zero-price strategies must make money from somewhere. Otherwise, they would just go out of business. Just to give an example, CBS or ABC that provide free over-the-air broadcast content do not do so without making a profit, or at least hoping to. The existence of a free product usually indicates this related positive price product, and the economics of those two goods are related. A proper antitrust analysis should consider the free product together with its companion money-making product. When a zero-price product or service is supplied over a multi-sided platform, it may be necessary, as the Supreme Court has ruled, to consider all sides of the platform before reaching a conclusion regarding market definition. As I mentioned, I believe the Second Circuit got it wrong, but we're bound by the rules of the Supreme Court. And in the recent Ohio versus American Express, they held that at least for credit card transactions, we must include both sides of a two-sided platform when defining the relevant antitrust market. The court explained that platforms may need to charge different prices to account for different demand elasticities, and therefore price increases on one side do not suggest anti-competitive effects without some evidence that they have increased the overall cost of the platform services. I consider this a challenging and development for the antitrust laws. It's not necessarily easier task, but I think in the long run, it can be a healthier one than what one of the tests that was proposed, which was to not recognize the pro-competitive efficiencies of the vertical restraints in these types of two-sided markets. The relationship between free and paid products in the zero-price economy also informs whom we treat as a relevant consumer. There's a saying that if you're not paying for it, you're the product. Users of a zero-price product in some cases simply may be the input to the final product. And we've talked about the broadcast TV industry, where the actual advertisers are the ultimate customer, and that's where we look at for our analysis. Third, it becomes particularly important to look at the non-price competition. Price is only one dimension of the competition. Firms in zero-price markets continue to compete against each other. And these factors are part of our traditional consumer welfare standard and deserve our attention and perhaps a renewed focus from academics in this area. A recent Harvard Business Review article observed that a number of constraints on a digital platform's success, even in markets characterized by network effects. The article, and this is written by business school professors, not lawyers or antitrust economists, but I would encourage everybody to read it if you have an interest in this area. It's by Professors Feng Zhu and Marco Ianciti, that was just in this month's Harvard Business Review. And they first point out that the strength of the network effects can vary dramatically and can change over time. While network effects often lead to competition for the market rather than in the market, they do not necessarily create durable market power and actually could lead to a new entrant toppling the market power that those platforms have. In the video game industry, for example, companies have alternated taking the lead over the years depending on who has the newest technological advantages and the hit games. In the 90s, Windows was a leading operating system for application developers, seemingly entrenched by the strength of its network effects. But technological developments allowed to compete by the Antitrust Division's enforcement activity and shifting consumer preferences helped Android and iOS mobile operating systems to provide new choices and whole new markets for consumers. As these and other examples demonstrate, there are many different factors that play into a platform's success or failure. We as antitrust enforcers need to pay close attention to the competitive constraints, to first make sure we don't enforce away pro-competitive business models, but also to be vigilant that conduct does not unreasonably constrain the ability of new competitors to compete on the merits. If we fail, we may very well see the costly, inefficient, and inflexible government regulations necessarily have to step in. Some have already called for that. The title of this conference is Internet Platforms, Rising Dominance and Evolving Governance. And we've been asked, among other things, to evaluate the appropriate strategies for overseeing platforms. In answering that question from the perspective of antitrust enforcement, we should remember that market power is not unlawful on its own. The question for antitrust enforcement is not how big the platform is, but whether the platform is what it's doing harms competition. Some critics say the platforms are too big, have too much data, or too many users. We must be vigilant to study the causes and effects of the market power. In doing so, we must remind ourselves, however, that an efficient firm capturing unsatisfied customers from an inefficient rival or an incumbent is, as the Supreme Court explained, quote, precisely the sort of competition that promotes the consumer's interests that the Sherman Act aims to foster. The benefit of our capitalist free market system is that winners and losers are determined by the market, not chosen by the government, and a great lasting, I think, impact of the former Supreme Court Justice Robert H. Jackson and the FDR administration. Many of today's large platforms have grown because they've provided innovative and disruptive services that consumers seem to like and want to use. And in my view, it's no accident, and I think a point of pride, that the majority of these leading platforms are American companies. Our pro-market economic and legal structures, our venture capital community foster innovation and entrepreneurship. The fact that successful companies can reap the benefits of their hard work encourages the next generation of innovators and entrepreneurs and inserts the dynamic competition that best benefits consumers. Therefore, again, as the Supreme Court explained in Trinco, to safeguard, quote, to safeguard the incentive to innovate, the possession of monopoly power will not be found unlawful unless it is accompanied by an element of anti-competitive conduct. We also are wise as enforcers and policymakers to remember that, as the Supreme Court explained, quote, the purpose of the Sherman Act is not to protect businesses from the working of the market, it is to protect the public from the failure of the market. Concerns over privacy, inadequate notice, unauthorized use of data, data protection, and others are legitimate policy issues that need to be discussed, but should not lead to distortions of our antitrust standards to address them. The digital economy and the increasing number of zero-price strategies have brought enormous benefits to consumers. Our role as antitrust enforcers is to protect the free market in which the consumers are free to choose whatever product they want at any old time. We do this ideally by guarding against collusive and exclusionary behavior that distorts the free market. Thank you. Yes. One of the benefits of having a crystal clear presentation.
I do not.
We answered it all.
I'm sorry. You mentioned a little bit about price discrimination. It's a topic that I've just learned about in Professor Weiser's class. I was wondering if there were different forms of versioning that you found were more harmful than others, and when regulation is necessary for more harmful versioning practices.
Well, I mean, I don't know if you have been learning about the great Robinson-Patman Act and price discrimination related to that, but, you know, as far as what we have found, you know, it's not an area that is currently subject of vigorous enforcement, the Robinson-Patman Act. But to the extent that different pricing strategies the market and the consumer, depending on who you're dealing with. There's a lot of this being litigated in another context where people actually commit to non-discriminatory pricing practices. And I've argued that those are probably better addressed through the contractual laws and the judicial fact-finding of whether you have violated your non-discriminatory pricing, depending on who you're selling it to, small business, a big business, different pricing strategies, rather than an antitrust problem. But I hope that answers your question.
In a series of recent transactions, many people have raised questions about the independence of the DOJ and whether there may be some political agenda at work. Without asking you whether that is true, how can you assure people that that's not happening? How can you maintain the reputation that the Department of Justice has built up over decades for applying the antitrust laws in a politically neutral fashion and not being subject to interference by the White House?
Well, of course, there are policies in place both at the White House and the Justice Department. And I think the transparency of what we do, I mean, many people raised concerns and questions in the previous administration, which I don't necessarily agree with, that somehow Google's presence and prominence in the Obama administration affected the FTC's investigation of and prosecution of Google in a very high-profile litigation just in the very beginning portions of my tenure of this administration. In a multi-billion-dollar merger in the media industry. As part of the litigation strategy, the companies tried to use that as an issue. And they raised it, and I think probably did a lot of disservice because it raised questions about the motivations of a case. But it was a public relations and a litigation strategy, which I totally understand. But I think it probably ultimately did a lot of disservice to the public and their confidence in what the Justice Department does broadly, but what the Antitrust Division does. I think there's broad consensus on the consumer welfare standard. I mean, I don't think Carl Shapiro and I voted the same way last November. It's probably safe to say that. But he was our expert in that particular case, as were others who were involved in the early stages of that investigation. So I don't know how much Donald Trump influenced Carl as I people love to write stories. Recently, my favorite one has been how many times certain merging party executives spend at the Trump Hotel, and how that's done deliberately to affect my views on a particular merger, which, of course, it's an important fact to the point where we've actually changed our merger guidelines to include the number of nights you stay at the Trump Hotel and the number and they forgot to write about, but maybe the Post will write about it, the number of rounds you play at the Trump golf course factors into our decisions in these cases. So it's a lot of BS. The media loves it, and I think a lot of that is the effect of the last elections and the raw, I think, emotions going on. But there's direct policies, and believe me, there was a lot of discovery in that litigation that occurred, and a lot of information that was turned over. If there was even an ounce of evidence of such an influence, the very well priced lawyers and public relations experts in that transaction would have shown that to the public.
I'm going to give the mic to myself for a second. So would you say that the consumer welfare standard is completely sufficient, or do you think that it needs to be updated?
Well, so the consumer welfare standard, I think, is a good standard for antitrust and to protect the markets and the purposes of the antitrust laws. And some people may criticize the Chicago School and Judge Bork's very influential book and writings called The Antitrust Paradox. But I would also point to Judge Bork's op-ed in 1998 in the New York Times, where he said what antitrust is or what it isn't. Forget the exact title. But he said that the principles, he said one of the problems with antitrust law back until when he published it in 1979, he actually wrote it in 1969, but was that there weren't neutral principles to apply to it. And antitrust was a policy at war with itself. And you need some basic neutral principles that remains constant. However, our thinking changes with our new economic understanding. There were a lot of practices that the antitrust laws in the Justice Department prevented that ultimately were shown to be pro-consumer later, and that those policies change. And that's where the flexibility is important. But it doesn't mean that all vertical restraints are perfectly per se legal, because as economic thinking changes, the laws are allowed to change. And I think Judge Bork's op-ed is a perfect way to describe that. And Carl Shapiro's paper and his testimony before the Senate Judiciary Committee are good ways of thinking about it. Do you have
Go for a final question from Blake.
Thanks so much. Just thinking about the topics that we'll explore down the road. We've spent a lot of time during this conference talking about concentration in the big telecommunications firms and among some of the big internet platforms. There's obviously discussion more broadly about concentration in a variety of industries. There's an interesting report about, concentration in cat food and peanut butter and jelly and craft stores and everything else. I'm just wondering from your perspective, as you think about what are we not talking about here in terms of concentration in the technology industry, or what specific sectors are on your radar that we ought to be thinking about over the next year or two?
It's an interesting point. I mean, so one of the things we're looking at the division that we've announced, they're coming. We haven't announced the exact date. We're going to do a 2-day workshop on broadcast industry and the effect of how advertising dollars have gone to platforms, and how does that impact our merger analysis or Section 2 analysis? Does it or should it? Have the customers changed in the spot advertising market, for example, or that's an area which is interesting, and I don't know what the answers are. The purpose of it is to bring really thoughtful experts in the industry for us to learn, to see if our tools need to sharpen further in this area, or are we still applying the right standards? The other, I think, interesting one is friend Einar Elhaig wrote a great article recently. I don't agree totally with it, but I've recently read it over the holidays. But several others have also done so, including former, in the previous administration, I think Carl's successor, as Fiona at Yale, about the issue of institutional investors and passive investment in different, especially in concentrated markets. How should we look at that from a competition standpoint? And when you look at that versus private equity or other activist interests in a company and owning the public shares, do companies who know that one of their largest shareholders also was a large shareholder in their competitors, and this is outside of what the Section 8 context, do they behave differently from a competitive standpoint? Whereas you might have private equity or activists who go in and they actually want to compete because they want to raise shareholder prices. That's another area we're going to be looking at, and it's I think a fascinating area to see how whether or not competition laws should pay attention. But there are so many others. One thing I don't agree with is how I think we should be vigilant and take a look at the platforms and the technology companies. But those who have entered into the market because of inefficiencies and the offerings to consumers of their products, because they want to keep a certain business model. I'll just raise Netflix as an example, or the video side, where the consumer all of a sudden could have access to certain content and a lot of content to watch anywhere, a lot of flexibility in how they consume that information. And then all of a sudden they gain traction, and then they change their business model, go to original content, that somehow they are the threat to an old business model that hasn't shifted yet, and therefore it becomes a defense to an otherwise illegal violation of the antitrust laws. I think that is wrong way to look at it. Of course, lawyers are creative and will offer that as a defense, but hopefully good courts and judges who understand economics will not adopt that. Thank you so much.
Thank you. Thank you. Really appreciate it. So we come to the end of a great set of discussions, and I've invited a number of people who are bringing with ideas to contribute that to the journal as part of this ongoing discussion. And others, talk to Blake, talk to Dale, myself, Anna, thoughts, ideas for next year, either for different foods to the breaks or different food for thought. We welcome all that feedback. We appreciate all of your support and engagement, and please enjoy lunch, continue visiting, and again, thanks everyone for a great conference.